Hello, everyone. My name is Jonathan Kewley. I'm the co-chair of the tech group here at Clifford Chance, and it's a real pleasure to be welcoming you today. Over 1,000 of you registered for this session to talk about AI and AI regulation globally. And we're speaking at a really exciting time. So last year in 2023, $92 billion of investment in AI, VC funding up 58% on last year, a real bright spot in a otherwise somewhat challenging market. And to put all of this in context, it took Netflix 3.5 years to achieve the same growth which ChatGPT had in just 1 month. So we're big fans of AI here at Clifford Chance, and we also have a landmark partnership with Microsoft. All of us have access to Copilot, over 8,000 of us. So this is not a session to talk down AI, but it's a session to discuss how to control it. And in that vein, storm clouds are on the horizon. So the AI Safety Summit in London, which just about every global government attended last year, called for global action on this. And I was looking back at some Elon Musk tweets recently, as I do in my spare time. And back in 2014, he said, we need to be super careful with AI. It's potentially more dangerous than nukes. Others now share this view. So the Future of Life Institute, for example, published a letter last year. 30,000 people signed it, requesting an ethical pause on AI use. And Steve Wozniak, the Apple co-founder, and also Elon Musk signed that letter. But we haven't seen that ethical pause. There's also some interesting gender and diversity issues for us to explore in this today. So, for example, in the UK, only 15% of people studying computer science at A level is a woman, and only 1 in 4 people globally in tech is a woman. So, as a founder of a scholarship program with Oxford University to get more diversity in tech and encourage more women and people from diverse backgrounds to go into computer science, this is something that's very close to my heart and something that we hope to discuss today. And we've gathered a stellar cast for our global discussion. And this is a very much a global discussion as we look at this regulatory tide, which is facing every business. We have my co-chair of the tech group, Devika Kornbacher, joining us from New York. Hi, Devika. We've got Stella Cramer, who's our head of our tech group in APAC, joining us from Singapore. Hi there, Stella. We've got Dessislava, who's the head of our Continental Europe tech group, joining us from Paris. Hi there, Desi. Phillip Souta, who's our global head of tech policy, who runs our tech policy unit in London. And last but by no means least, Chen, who joined us from Beijing, China, to discuss a really interesting developing landscape in China, one of the most sophisticated legal landscapes for AI in the world. But first, we're going to turn to the US. We all know that this is a global challenge and one which the US doesn't want to be caught short on. It wants to lead the world on AI regulation and safety. Kamala Harris came to the AI Safety Summit, and since that summit, there's been a series of announcements from the US government and a Biden executive order on AI too. So on that note, over to you, Devika, to give us a summary of what's happening in the US.
Sure, and I'll come at this presuming there's some baseline right knowledge with the EU AI Act being out there and pretty comprehensive, right? The US, when it comes to regulating AI, is doing it the same way it's done with most other things, meaning relying on Congress to come up with something really comprehensive and covering all things is not going to happen quickly, if at all. And so in the US, the approach has been like, that's why the ethical pause, I think, Jonathan, was asked for with a very US-led force, is because innovation is flowing fast, but the regulation has been slower. So Biden did come out with the executive order as the quickest way to get the voice out there. And the whole name of it is right, the Biden executive order on the safe, secure, and trustworthy development and use of artificial intelligence. So it's not as easy to say as the EU AI Act, but the idea of it is fine, since it's going to take a while for Congress to put things out that they may regulate private industry directly. The executive order says government agencies who do regulate these private industry and other participants, you need to come up with something. And so it's 6 months since that order has come out. So this is a nice, timely seminar, because now we've seen some of the deadlines expire. So there were like 30-day and 25-day and 3-month deadlines. So we've already seen the Safety and Security Board has been appointed with 22 inaugural members, including CEO of OpenAI. There's also others. And the idea of this board, they're going to advise the Department of Homeland Security on critical infrastructure. And then there's the NIST has been mandated to give some more help besides the risk management framework. For those who haven't been following it, NIST has one of the leading risk management frameworks, but that is not a regulation. That's a guideline. And so NIST has been working on other guidelines around Gen AI specifically. And then we could talk for a while about just about the federal level, what's happening with the SEC, enforcing existing regulations. So I always like to remind people, while we're talking about AI specific regulations in this call, the existing regulations on privacy, cybersecurity, all the civil rights, they're still there. And the US is not scared of enforcing them. So agencies are already, like the FTC, are already using the Unfair and Deceptive Trade Practice Act prohibition in Section 5 of the FTC Act to come after companies that they feel like have not been fair. Same thing with the SEC, the mandate to be upfront and telling investors everything has resulted in an AI washing fines on 2 different companies. So it's happening. And then the state level, Jonathan, hasn't stopped either. It's not waiting for the federal government to do anything while the Biden EO is still making its way. And we'll talk a little bit more about it later. Because, for example, I'm an IP lawyer, has come out with their guidance. The states are also at it. So New York and others have very specific human resources type regulations that are out there that say, for example, you have to get a bias audit. New Hampshire has said things about what they're going to do in their government, Colorado. So I could list it for a while, but just know that the US is seeking to regulate it just in a different way, right? Regulating AI with existing regulations, but also AI specific coming from federal, state, and local level.
And can you say a bit more about, so the Biden executive order is interesting, isn't it? Because it majors on testing, and it has a big focus on cybersecurity. And one of the kind of aspects of this area which makes it so challenging for legal teams and really requires a multidisciplinary approach is that there are so many different topics to cover. But the Biden executive order is very focused on companies testing their models for robustness and security. It'd be great to hear a bit more about that.
Well, I think that the testing is more the real concern of dual use models, the idea of these foundational models that can be used not just for the thing that they're put out there for. Think about like a GPT out there. Yes, there's a chat bot, but that same model could be used for several different things, including cybersecurity, including attacking other nations, right? That same generative pre-trained transformer model can be used for many things. So I think the Biden order was focused and continues to be focused on trying to get at the root of what feeds and is the father, mother, parent of all the other AI that the Elon Musk was talking about being more dangerous than nukes, right? It's not necessarily data analytics platforms. It's these giant quintillion bytes of capacity that can be processed through these dual use foundation models, Jonathan.
Yeah, fully. And I guess the really interesting aspect of cybersecurity on this is that businesses are incorporating this technology at speed into their platforms and their technology stacks, but actually the technology from a cybersecurity perspective is relatively untested, and there are significant gaps in knowledge and expertise in how to test it from a cybersecurity perspective. So we'll be coming back to that in a little while. I'm going to go next to APAC and to Stella, because again, for this conversation today, we want to really give you the message that this is a global discussion. And if you're starting off on the journey of AI governance, and many companies are now doing that at speed, you can't compartmentalize it. You have to think about it from a global perspective. And so on that note, we'll go to Stella next.
Thank you, Jonathan, and delighted to be here today and part of this very live global discussion for our clients. So Jane and I are going to give a little bit of an overview as to what is happening in APAC. And we're going to be focusing specifically on 2 jurisdictions that are taking quite different approaches. First of all, China, where we're seeing a much more prescriptive approach to the regulation of AI, and in fact, a first mover in terms of issuing legislation in respect of specific use of AI, most most recently the use of generative AI in China, and also in respect of the use of deepfakes and decision-making algorithms, then I will sort of consider the approach that Singapore has been taking, which has become effectively a blueprint for many countries in the region who are supporting a pro-innovation approach, but underpinned by the importance of having strong information security and cyber risk resilient foundations against that sort of backdrop. But first of all, Jane, it would be great if you could just give us a bit more of a detailed overview as to what is happening on the ground in China and its response to regulating the risks of AI.
Thanks, Jonathan and Stella. As Stella has mentioned, China has been one of the first countries to regulate AI matters, and the approach it takes is a bit vertical and fragmented. While at this moment there's no national legislation regulating AI, PRC regulators have identified the areas of high focus and issued specific guidelines in these areas, so such as the deepfakes, recommendation algorithms, and generative AI services. And one thing we'd like to highlight is that in respect of the generative AI measures, it actually has an extraordinary effect. Therefore, the rollout of any global AI project will need to consider this fact carefully. In terms of how the regulations be shaped, each of these regulations will set out implementation guidance for the relevant service providers and users to follow. For example, it will outline the measures required to protect data, privacy, IP rights, and it will also outline the platform responsibility to monitor users and implement user protections. All this will be included in one regulations. And if we look forward a bit, we also see that in China, a group of Chinese scholars have been preparing and starting to draft the model law on artificial intelligence. Whether this will be moved forward to be a national legislation regulating AI matters is something interesting to watch out for. And another interesting update we would like to supplement is that this March, China actually relaxed its measures on cross-border transfer. This means that for global AI users, they can now consider how to better use the data in China and how to develop the international collaboration business model. And we have seen a number of clients have been reconsidering their data governance work and restructuring the data flows accordingly. Yeah.
Thanks, Jane. And I guess one of the interesting features of legislation in China around this is that there's a registration regime, right? So for sort of dangerous technologies like deep fakes, there's a requirement to actually go to the government agencies first and get their permission before using it, which is kind of a first globally, this kind of registration regime.
Yes, correct. This aligns with the Chinese regulators' approach when they will consider that some service or products will have impact on social interest. This could be something like national interest, security matters, and also could be something like soliciting public opinions and data features. In that case, additional regulatory filings, such as a security assessment or registration with a regulator will be required.
Thanks, Jane. And I should mention for our audience today, if you have questions, please put them in the chat, and we'll run through those questions towards the end of the session today. But please ask away. We're here to help. Back to you, Stella.
Thanks, Jonathan. So I mean, already everyone can see that there's this fragmented approach that's happening in APAC, and obviously not only in APAC, but there are the issues that clients are facing here on the ground around managing the regulation that's coming out of China, managing the extraterritorial impacts of the EU AI Act, and then also what's happening on the ground in multiple countries, and also on a sector-by-sector basis. And sort of coming back to Singapore, it's been quite interesting to see the approach that's being adopted here to really sort of help help drive innovation and sort of position Singapore as a hub, which has been quite influential and had real impact across the Southeast Asia region, because we're seeing other countries take similar approaches. And Singapore, first of all, at an intergovernmental level, has entered into multiple digital economy agreements with different countries looking to help facilitate digital trade and also reinforce the importance of collaboration around the adoption of artificial intelligence. We've then seen amendments to existing laws such as data protection laws and the Copyright Act to help facilitate innovation. And then we've seen numerous guidance frameworks be issued by the financial services regulators and also the general data protection regulators and the IMDA, one sort of focusing on responsible use of AI and risk management frameworks around that. And these were issued back in 2018 and 2019. So again, quite ahead of the curve. And we're seeing these frameworks now be adopted by the ASEAN group of nations to support the responsible use of AI across Southeast Asia. We now also have the Model AI Governance Framework for Generative AI. The consultation has just finished on that, but that covers 9 additional aspects of consideration for generative AI use in Singapore. And there's been a number of interesting collaborations with the regulators and industry that I'll touch on later to help facilitate testing and toolkits around the transparency and risks of AI models. And then my final comment really would be around what's happening around cybersecurity and information security, not only in Singapore, but more broadly across the region. And we're now sort of seeing a number of new laws either going through the legislative process or being passed, focusing on digital information infrastructure and cloud service providers and data centers to ensure that they meet various standards, technical standards, codes of practice. There's also rights of audits, mandatory breach notification requirements to ensure that digital infrastructure that's underpinning these AI models meets cybersecurity requirements to ensure that those cyber risks, Jonathan, that you were addressing earlier are picked up.
Thanks so much, Stella. And we'll return to some of those themes a bit later on today. But I think now we'll turn to Europe, which is clearly the powerhouse of AI regulation globally. With GDPR, it was first out of the blocks with data regulation 5 years ago. And we now have some of the most sophisticated data laws in the world in Europe. And we believe that AI legislation is going to follow a similar trajectory. And so I'm sure many of you here today are going to be listening in earnest to what Europe is proposing around this, and also when the laws start to take effect. Some headlines before we pass over to Desi. So extraterritorial. So all of you who are familiar with GDPR will know about this. So if you're a business in the US, but you're developing models, AI systems that will be deployed on consumers in Europe, you'll be captured. So regardless of where you are in the world, 7% of global turnover fines for non-compliance. So that's even worse than GDPR, and very significant disclosure obligations to regulators. So if you're joining this call today to hear about how you should start to set up your program, you're in the right place. And many people are now accelerating this and kicking off very significant AI governance projects. So on that note, I'll hand over to Desi and perhaps ask firstly, what's the status of the legislation, and when can we expect to hear more from the Commission?
Yeah, thank you, Jonathan. Well, it's been a long process, wasn't it? And not necessarily one that has been very easy to follow for those looking in from the outside. But the key is that, as you say, after years of work, hotly debated topics and protracted negotiations, we are almost there now. We are waiting for the last approval by the EU Council, which is imminent, really question of days. And after that, the EUA Act will be published officially, and 20 days later on, it will enter into force. but it will not apply immediately. So where did the text land in the end? As you were saying, some of the key principles of the text have remained unchanged since the beginning, like the extraterritorial reach, horizontal nature, comprehensive requirements associated with very significant sanctions, a tiered approach involving a ban on the most dangerous practices, and detailed requirements for systems deemed high risk. That said, there have been some significant developments since the Commission's initial proposal back in April 2021, extending the scope of the AI Act to cover new fundamental concepts. I'll take just 3 examples, but there are many more, actually. First of all, regulating generative AI and general purpose models, which is one of the most important and highly debated developments in Europe, but actually at the global level, due to the explosion of ChatGPT. The new rules involved a tiered system with rules for all general purpose AI models and additional ones for general purpose AI models with systemic risks. Secondly, strengthening the governance framework, because it is all about enforcement. And here we'll be seeing a multi-layered, very complex governance framework that has been introduced and reinforced recently, and in particular, the creation of an AI office, a body that will have a key role to play, including with respect to general purpose AI models, and also more generally around the international cooperation. We'll probably discuss that topic a little bit later on. Thirdly, but certainly not lastly, AI literacy, which has become at the core of the AI Act requirements that every company and every business will need to take on board. So
and that's regardless of risk, right, Desi? So if you're an organization and you're not using high-risk AI, and we'll come on to the kind of definition of that in a second, but if you're not using high-risk AI, but you're using it in some form, you're going to have to start to educate your workforce about the opportunities there, but also the risks.
Totally. And interestingly, this is one of the requirements that will kick in amongst the first ones in 6 months. So companies will need to be prepared and really act. So how the entry into effect of the AI Act will be kind of done in sequencing manner. So 6 months with the prohibited practices application, and then the literacy requirements kicking in. Then 12 months later, the rules on GPIA models. 24 months later will basically by default entry into effect for all other requirements, and 36 months for the sector specific requirements and alignment that will need to be achieved.
And I know people will be very focused on that, sitting in the audience and thinking about the next 6 months. So let's say the law goes fully live in June, and then they have 6 months to assess what prohibited AI practices are. Could you say a bit more about that? Sort of, because I think the message from us is that this work needs to start now, even though it's a staged and a tiered timetable. I think companies would be quite surprised to learn the breadth of prohibited practices, and actually they may have certain of those lingering in their technology stack that they're not aware of, or vendors might be using those, and they might maybe inadvertently purchasing those.
Totally. And by the way, the scope of the prohibited practices was one of the hotly debated areas of the AI Act in the last month towards finalization, with the real extension of the scope. So systems aiming at emotion recognition at the working place or social scoring will be prohibited. And it is so easy to be captured by the text that it is fundamental that businesses start mapping and prioritizing their activities. Yeah. And as you say, the areas of focus should really be prohibited practices, then secondly, literacy more generally, and thirdly, having a realistic and pragmatic roadmap towards implementation, but we'll probably come back to
that for sure. A little bit later. We want to spend a lot of time on the call today talking about the practicalities of this, because obviously it's a highly technical area. The EU AI Act is 500 pages long. It's a very dense piece of legislation, There's not a lot of guidance around it now, so that will be released in the coming months and years, so not super helpful for business. So we want to fill that gap and talk to you about how to approach one of these projects. But before we do that, I might just turn to Phillip, because as this global discussion continues to evolve, it's really important that companies have a voice in the policy community around AI, because there is an ability to influence regulators and governments around this. And the law is not fully finalized globally, it's evolving. And so having a voice is absolutely vital. And Phillip, it would be good to hear from you about some of the work we're doing in that area and your thoughts.
Sure. So we have a tech policy unit, which we set up a little while ago, and unsurprisingly, we are pretty busy. The work that we do is about what is coming, how to shape it, and if you can't shape it, how to deal with it. So one of the things we're seeing is companies being really quite stretched by what seems like this constant stream of regulatory approaches. It's not just dealing with complexity and contradiction across all of these jurisdictions, but ensuring that nothing is missed or spotted and then responded to too late. And with so much going on, that is actually a really material risk. And we've seen that happen with sometimes quite messy and unpleasant consequences. We think it's really important to be active in this space in order to be able to understand it and really to be able to deal with it. So we were a founding member of the AI Fringe, which happened alongside the AI Summit in London last year, and which goes to France and South Korea this year. We are also creating tech policy forums where we discuss all of these issues with clients and others, including NGOs and advocacy groups. And we're using those to help develop thinking about the best policy outcomes and how to advocate for them. And I'd like to sort of give 3 examples of what we're doing a lot of in the tech policy unit right now. So firstly, we have seen a really increased demand for horizon scanning of regulatory and legal developments as part of clients and companies' strategic forward planning. And that will often involve incredibly granular monitoring of multiple agencies and authorities in EU member states, and sometimes down to sort of individual US states. So there's just an awful lot to keep on top of. Secondly, we are doing an awful lot of stakeholder engagement and advocacy. Policymakers, regulators, NGOs, advocacy groups. We're doing a lot in Brussels around data privacy and AI, the issues that are going to define the next Commission mandate following the June European elections. So people are very active in that space because a lot is going to change. And finally, we are working very hard on these incredibly complex projects, like, for example, the implementation of the AI Act, because it's going to become law probably around June, as we've discussed. There is this staged implementation timeline, but there is still an awful lot to do in terms of member state authorities issuing guidance, and there are still conversations to be had, and the devil's in the detail. And so we're talking still to a lot of policymakers about exactly what that detail looks like. So pretty busy.
Thanks, Phillip. And I think if any of you have had the opportunity in the audience to read the 500 pages, there's quite a lot of uncertainty, actually contradiction in there. So the ability to influence is going to be very important. And if you'd be interested in hearing more about the tech policy unit, do reach out to Phillip after the discussion today. But back to you, Desi. Thinking about some of these foundational principles of the AI Act, which will become the norm globally. Tell us a little bit more about high-risk systems, because the AI Act doesn't regulate all AI in the same way, which I think for many in the audience will be a relief. You're going to have to risk rate the AI that you use and start to triage your response, and to ensure that your governance is pivoted to the most serious forms, most possibly damaging forms of AI. So could you say a bit more about kind of high-risk AI systems?
Absolutely. The approach that was adopted and taken by the EU legislator is to have a proportionate programs that would apply depending on the risk raised by the AI systems at stake. So it goes from prohibited, as we already mentioned, through high risk, then some specific AI systems that require particular attention in terms of transparency and information to users, and then some transversal and generic rules that apply to all AI systems, and in particular to GPIA models and GPIA systems, some of which with systemic risks. So for companies, it will be essential to map the areas that are actually impacted by the AI Act in terms of internal use of AI or use of AI with their customers, and then adopt the governance and the structure and the compliance programs that will be implemented.
And I think people will find it quite interesting, won't they, that some of these high-risk AI systems are not sort of Terminator 2 systems. It's not focusing just on kind of what OpenAI might be doing. So, for example, HR is a high-risk use case, right? And as we see in the work that we do, there's a huge amount of AI-empowered HR technology out there. So we don't get the view on this call that this is somehow an abstract risk. It's very close to what most companies are doing now.
So our initial kind of conclusion, having accompanied clients on this type of discussions, is actually that almost every company can potentially be in the field of high-risk AI systems use. The example you gave is an obvious one. It's really the use of AI with respect to HR, employment, recruitment, promotion, termination. Same for education purposes. Same for the use of AI for access to some essential services, or creditworthiness is another example, or everything around insurance, life insurance, and pricing. This is also being considered as high risk. We should say that there's some good news as well, because companies can go for an auto assessment and consider that some of the systems they use that would automatically fall within the category of high risk systems can actually benefit from an exception, which would apply to systems that are being used for mainly procedural tasks and administrative tasks. It will be a high test to reach, realistically, however.
And I'm sure that before we move to Devika, people will be interested, I think, as well in the definition of AI. So early on, it was exceptionally broad, and people were kind of saying, "Oh, will it cover, use of Excel spreadsheet?" The definition has narrowed. So AI systems, we now have a definition in the Act for it. Could you give a bit more information as to what it covered? Because it's narrowed, but it's still relatively broad in scope and captures a lot of technology that companies will be using.
What we have seen, that's a very good question. And what we have seen with the definition and the debate around it of AI is actually quite reflective of what is happening at the global level, which is somewhat governments and countries and regions converging. So the AI Act, the initial version, went for a very extensive definition of AI. As you say, it's almost covering every Excel sheet. Now, the EU legislator came to a conclusion that the OCDE definition should become the one used not only in the EU, but we see that happening everywhere. And that's, I would say, a positive news. Obviously, it is still very, very, very extensive. Let's be realistic. It will cover any algorithm able to infer objectives and output, but it is more realistic and better and positive news for companies that are acting at the global level.
Yeah, so to be clear, like machine learning is captured. This concept of inference is very important. Generative AI is captured within the definition, but systems which are purely based on logic only, with not this concept of inference, would not necessarily be captured. So again, we'll come on to kind of scoping this and starting a project, but being clear as to what AI will be captured by this in your organization will be vital. I think, Devika, I wanted to turn to you next to talk a little bit about supply chain management and buying in AI, because a lot of companies will not be developing their own proprietary systems. They'll be purchasing it from the likes of Microsoft and OpenAI and others. What are you seeing in terms of how companies are approaching that? Because clearly the contractual framework around procurement and how you're purchasing these technologies will need to change, and will need to change quickly. So it'd be great to get some kind of guidance from you around that.
Sure, and I will say, because everything that's happening with the AI Act being extraterritorial, but a lot of the supply chain is not, meaning the supply chain is not in one territory, it's going everywhere. So this idea of where you get supply from, Jonathan, is also a live conversation. So deciding to source from China, deciding to source certain things from Europe or to release it in Europe has resulted in a pause in the way procurement has been going out to get things normally, right? If something's usually low cost, indirect procurement or procurement just gets it, clicks the terms and comes in. What we've been seeing lately is organizations that are attuned to this are saying, okay, wait, are at least raising the flag for procurement, that anything that may somehow talk about an AI model, an algorithm, needs to go through legal or needs to go through at least another set of eyes. One big thing we're seeing a lot is, and I'll say this for those who are in the audience, watch those renewals. So organizations that have been a supplier to you before have now added an AI tool, and a lot of them want to learn off of your data. And we've seen large organizations who have multi-million-dollar renewals added as an addendum. Oh yeah, just renew. It's the same contract, and here's an addendum. And it has all these terms in it that say things as bold as, you give us consent to use your data to train our AI. So there's also the things you're taking in, you may be helping unknowingly, helping someone else train off of your data and make money off your data to sell it back to you. But then for companies who are being very focused on AI, meaning like they want to develop their own or at least outsource for certain purposes, including some high risk things like HR, the idea of contracting around that risk is what we're advising on a lot because of where the regulations are. So things like ensuring you have transparency as a partaker of it. I need to be able to see what's inside. Of course, there's like the suppliers like, no, you can't see, it's a secret. But then the alternative to that is to say, well, fine, you will help me when the government asks me what you're doing, and you attest, there's some warranties that you have done it in these different ways, right? You have thought through it. Your data provenance has been thought through. You've thought through cybersecurity testing, to your earlier point, Jonathan. So being very thoughtful in the way your provisions read, not just saying generally you'll keep it secure, but thinking about models, using the terms like who's going to own the output, how is the input going to be done. Integrating those terms to typical IT contracts is essential right now, because the loose terms of old will kind of land you in a no man's land in a short time.
And it's not about reinventing the wheel, is it? Because I think lots of the companies in the audience today through GDPR will have developed very kind of sophisticated vendor management processes to incorporate standard contractual clauses and terms that are required under GDPR. So one of the practical pointers which we're saying is that you should look to the vendor framework you formed around data management and pivot that across to AI risk. And one of the things that we're seeing a lot at the moment, you mentioned cybersecurity, Devika. I mean, these models are being updated all the time. As an example, we receive software updates to Copilot every month, and therefore, in the old world, it may be necessary to validate the technology you're using, say, once a year, or to review an audit once a year. With this new world of AI technology, which is constantly updating and constantly learning, it may be necessary to test and validate much more regularly, which of course from a practical perspective means pretty quick engagement now with your vendor risk teams to have a bigger discussion around how to kind of build this out. I said that we get very practical, and I want the conversation to be very practical today. So Stella, if I'm sitting in a large multinational organization and I know I've got AI, where should I start? Like, what should I start with first? And this is again our theme of having a really global approach here. So we're looking at the EU AI Act, this seminal piece of legislation which is going to set this benchmark, but we're also thinking globally. Where should we start?
So I think we're seeing a lot of clients look at their governance structures generally across their organization and how they leverage their existing governance to manage the additional risks that are sort of compounded by the use of AI. And so we've been supporting clients, first of all, in helping them articulate their principles and approach and updating their sort of principles in respect of the risks of using AI. And then we've been looking at their governance structures and the need for addressing AI risks either through a separate AI ethics committee or through other governance structures, but very much looking to try and leverage what is already in place based on what organizations have been doing in respect of their management of data risks.
And in fact, one of the questions that's come through today relates to board level awareness of this. And I think one of the foundational things that we're recommending is that you speak with your board regularly around AI opportunity. And I'm sure lots of boards are looking at this and are kind of mandating innovation at speed, but also risk. And one way in which this can be addressed in terms of education and awareness for an organization in these early stages is, as Stella has mentioned, these AI ethics principles, which Clifford Chance have. We published ours just a few months ago, but that can be a real North Star, can't it, to kind of capture the imagination of not just boards, but also every employee in an organization. Can you say a bit more about those ethics principles?
So I think in respect of what we're seeing for those ethics, they're already embedded in a number of the AI risk frameworks we've seen emanate from regulators and also in legislation. And we see sort of the inspiration coming from the likes of the OECD and the EU and also across other regulation that we're seeing particularly out of here in Singapore in the AI guidance frameworks that have come out. And that really, as you say, Jonathan, really helps focus the discussion around, well, what is an organization's values in respect of these ethics, and how do we not only engage our management, but also our organization and our other stakeholders in respect of our position of managing AI risks globally.
And thinking kind of in this aligned way at board level is vital, because certain statements, for example, may be made in ESG reports around use of AI. For example, you may say that we're going to use AI responsibly and safely, but then that might contradict other aspects of your ESG report. So, for example, AI is hugely consumptive of energy and of water. And so connecting the dots at board level, educating your board, having these AI ethics principles, having some external oversight as well. We know that Google set up its AI ethics board. That didn't go very well. Employees rebelled and it got shut down within 7 days. So there's lots of interesting work to do around that. But let's just say you get to the stage where your board are on board, they're educated, they understand that this is a really important area of governance. And Desi, you've got a complex organization with perhaps many thousands of different models, some AI which may come within the EU definition, some which, if you get the approach right, may fall outside. You talked about mapping. Can you tell us a bit more about how you should do that from a risk perspective?
Yeah, absolutely. So it's a lot about planning and not being overwhelmed by everything that the EU AI Act will bring in terms of requirements. And so when I refer to mapping, it's really about defining the key areas of exposure and risk for companies, but equally key areas of opportunities, because not adopting AI, not using AI is actually a no-go and not an option. So in terms of having a pragmatic approach, once you have the board, your board involved, senior management involvement ensured, you have your principles, so you have the right culture, DNA, and direction of travel in place, then you start about thinking about a realistic roadmap. And a realistic roadmap starts with identifying these areas of risk I mentioned, by starting with the prohibited systems identification, because of the timeline that will really kick in very quickly. Then going to the high risk systems that will require structural changes within organizations at the global level, and additional, let's be realistic, additional resources and means and investments, which will of course bring some very costly decisions that will need to be made.
And in terms of creating that inventory, if you like, of AI, one thing I think that we're finding very helpful is engagement with audit teams. So, don't have the impression that AI is new. It's not. Within the definition of an AI system that captures technology, and particularly large financial institutions that's been around for 20 or 30 years, black box decision-making technology, it's really important to get a sense of where that sits. And of course, the mapping isn't just what you have internally, is it? It's what you're buying from third parties as well. So looking inside, but also looking out.
Totally, and you're totally right when you say that one of the challenges companies are facing is, where is AI sitting? So the only successful strategy that companies can put in place are about being holistic. So the internal audit function, but equally IT, then HR, strategy, etc. And that's what we see really happening at the moment in companies focusing on.
And so you categorize these systems by risk, and you determine that you've got a series of high risk systems, and that requires a deeper level of governance, control, and order. And one of the key parts of that, in terms of the EU AI Act, but kind of globally, is being able to explain how the technology works, this concept of explainability and transparency. And I just thought, Stella, I'd turn to you for a second to shed some light on that for us, because it's very important that this black box technology that has been opaque for so long, it is made open, that customers and regulators can understand how it's working. And to be clear, that's not easy, is it? It's a very difficult thing to achieve for this very complicated technology.
Yes, no, absolutely, Jonathan. And I think it would just be interesting to share with the audience a very sort of particular approach that Singapore has been taking around this. And it's really sort of consistent around its approach to collaborate with multiple stakeholders and industry. And it's set up what it's called the AI Verify Foundation, with the members including the big techs and also and the regulators, with a view to really being a significant contributor to the testing and validation of AI through this foundation. And it promotes the best practices and standards for artificial intelligence. And so they're working on a testing framework that's aligned with international AI governance principles and testable criteria and testing processes, and it allows businesses to complete a self-assessment to determine if their AI models meet the principles that they say that they meet. And they're also on top of that, and they've created this sort of open source platform, so developers can also continue to contribute to the development of these particular tools. And just as part of its sort of approach to collaborate, it's mapped these standards against the NIST framework that Devika was talking about earlier. So you can compare and contrast the two different frameworks to see where the commonalities, to really help facilitate the management of AI risks, and how to demonstrate that the models can be tested and demonstrated to meet some of these principles. But it's a work in progress. It's early days, and I think the fundamental issue is around sort of developing that globally.
And that's why in an organisation it's really important to form a kind of a brain trust around this, because you can get legal teams saying you've got high risk AI, and as a result of that you need to follow a life cycle management, effectively know where you're ingesting it, testing it, deploying it. If it starts to go wrong, knowing about that, switching it off, thinking about your supply chain. But all of this requires a really multidisciplinary approach between information security experts, ethicists, the board, legal teams, the engineers building the technologies vitally, and employees, the workforce that they're kind of brought on this journey. So we don't want to give the impression today that this is a purely legal work stream. It's not, but clearly the law is heavy. And going back into the spotlight of Europe, Desi, this concept of a life cycle, of understanding where your AI is, mapping it and tracking it, is, I think, for many, something which strikes fear, really, because it's like, okay, we can build our inventory, but this is technology which by its very nature is evolving. It's changing all the time. How on earth do we map that and track that? One of the ways in which you do that is to build this multidisciplinary team, but there's also got to be a system to oversee that for the complex record keeping, for the contractual arrangements around it, for the testing. So what are you seeing around that, the kind of the adoption of a system to help to oversee this?
Yeah, well, actually companies are busy preparing for the AI Act requirements to kick in. And typically this goes with requirements around quality and risk management systems that are specifically designed to track, to record, and to test the aspects you're mentioning, including how an AI system evolves, what are the risks that evolve, what are the mitigators that are to be put in place and how they need to evolve, what are the requirements that need to be and measures to be taken to ensure that some of the risks of AI systems are tackled in the best possible way. To give an example, it is around the quality of data sets that is being used for training, testing, and validation of AI systems. We all know how challenging for providers of AI systems, but equally for users of AI systems, is to ensure that the data that is being used is representative, accurate, unbiased, not bringing any discriminatory effect. And this goes with systems that will enable companies to show they have taken measures and considered appropriate mitigators around these risks.
And again, that's a really good example of where involving as a legal team, if you're looking at this, you must involve kind of data science team, because lawyers have a lot of the answers on this. But actually, if you ask, is a data set biased, or is a data set subject to data poisoning, that's not really a question that a lawyer alone can answer, but it's a question that the law requires you, the EU AI Act in particular, asks you to have answers to. So this multidisciplinary, multi-stakeholder approach is vital. Devika, you mentioned that you started out, you were an engineer, then you started out as an IP lawyer. Can you say a little bit about your views in terms of the impact of IP considerations in this space? Clearly, generative AI in particular sucks up a lot of IP. It's data is the lifeblood that flows around it. What do companies need to start to think about in the context of IP?
Sure. I mean, the first thing is to not think, oh, IP is not valuable for us, so I don't need to be part of this conversation, because the idea of input and output, even having intellectual property attached to it, could be considered revolutionary in a way, because it's data, right? So data shouldn't be protectable. It's a fact under normal international IP laws. But because that data comes in sets, it has protectability around the way it's organized. Because that data may be used to make something new through generative AI that might be protectable had it not been made by that particular model. Companies have to really think through, what do I care about protecting? And not just in a defensive way, but even in a proactive, creative way, what you're putting out there. Right now, just to give a quick fact, in most parts of the world, if something is generated wholly by a model, it is not protectable by the IP laws in most jurisdictions. There's areas like in South Korea. So there's some pockets where it may be protectable. And in most places in the US, the EU, it is not. Which means if the model makes it, you no longer can prevent a competitor from using it. Conversely, if you're using a model to make things, you may be hoovering up things that you didn't realize were protected, and the fair use defense that people are used to, for example, in the US, we're finding tested in the New York Times case, may not work. That defense may not work. The idea of, oh, it's not copying, it's caching, it's reading. Just know that even the daily activities in your organization, even if it's not somebody sitting inventing something for a patent, has a robust IP discussion that needs to happen around it, especially when it comes to the input and output of AI and how you use that input, how you use that output and how you get that input.
And one of the, I guess, the security concerns in the context of generative AI is that people may be prompting and inputting copyrighted material, for example, into that, which they don't have a right to do. So one of the areas that we're seeing some interesting testing principles come in is actually making sure that your employees aren't misusing copyright material and inputting it into into the technology. So thinking very holistically about this again, but kind of joining up the dots is absolutely vital. I said at the outset of the call that we would talk about diversity in tech, and we only have a few minutes left, but I think that's really important today because we know, for example, that algorithms can be exclusionary. They can deny customers credit based on their ethnic origin or their gender. We've seen very many examples of that. It's something that regulators are very interested in, but it's not just, we're not talking about this today because just regulators are interested in it. We are interested in it. And Devika, it would be good to hear from you on your thoughts in particular around the power of algorithms, both to do good, but also to do bad within society.
Yeah, and then that's one of the things, like you spoke about the bias, even knowing whether or not an algorithm is biased is being tested, and we're using technology that was made, and I think you've mentioned before, Jonathan, we've had discussions by a lot of, I'll just say, white men on the West Coast, right, with a particular point of view about what should be, or it's based on historical data that was already biased, right? So the idea of training lending algorithms on historic payment and historic lending means we're just perpetuating the bias. So a big part of what's happening now, and I know we're working with folks like Mirzilka at University of Cambridge and others, to how do you get to a great data set that doesn't have inherent bias, and if it does, you can identify it, and then making sure everyone's part of the conversation on how that model is made and how we fix it when it's broken. Because if the same people who made it are part of how to fix it, then the bias will never weed it out, or we won't even identify it. And so I think that's one of the key things. The last thing I'll say, the AI for good piece is, but in some ways, AI we found can be less biased than a human. So know that this AI algorithm is also being shown that if you look at it truly objectively, you would give somebody credit that perhaps that banker on the West Coast would not give that Black female.
And I guess, Phillip, this point around involving everyone in the conversation and actually not just thinking about law, but thinking about ethics as part of this project. One nice way in which I've heard it framed before is like, could we do it? But actually, should we do it? So, you know, having a global multilateral conversation within an organization around ethics and not just pure law is really vital.
Yeah, absolutely. And responsible AI is what everyone wants. You read the policy papers from all of the jurisdictions that we have been discussing here, from China to Singapore to the UK to the EU to the US, and all of them talk about responsible AI. So ultimately, in quite a meaningful way, we all want the same thing with different sort of cultural angles, but an ethical approach and baked in at the beginning potentially will save you from all sorts of reputational, economic, commercial issues down the line, in addition to just being the right thing to do in the first place.
Thanks, Phillip. And so I guess to close, the message from us is that these projects, these global AI regulatory and governance projects, are kicking off in earnest. We're working on some of the biggest projects in the world right now for some of the world's biggest companies. We have a lot of insights that we can share and discuss with you. There are low-hanging fruit here, so going towards these high-risk use cases, for example, like HR, or if you're a financial institution, you're doing credit scoring, looking deeply at how your algorithms are working in that space, going to high risk first, putting your employees front and center of this so they're part of this conversation, and also educating your board. All of these points are absolutely vital. And it's finally a global discussion. And we've had a global discussion today from every corner of the world. So we're delighted. Thank you to all of our speakers for joining us today. Delighted with your contribution. Thank you for all your questions as well, which I've woven into my questions as I've been moving through today. And to close, just to say we're here to help. If you have questions, if you have follow-ups, please reach out to any of us on the call today. We'd be delighted to help you with your projects and to go on this journey with you. It's an exciting world we're in. We feel very privileged to be working in this space, and we'd love to continue the conversation with you all. So thanks again for joining, and we'll speak very soon.